Welcome to the Retirement Classroom. Today's Strategy Spotlight answers a question I get from retirees constantly. Do you actually need a revocable living trust? The estate planning industry pushes trusts aggressively, and frankly, some attorneys make a lot of money creating trusts for people who don't really need them. But on the other hand, some people who desperately need a trust don't have one, and will cost their families tens of thousands of dollars in unnecessary legal fees. Today, I'm going to give you a completely honest breakdown. We'll cover exactly what a trust does, what it doesn't do, the real costs, the myths, and most importantly, a clear decision framework so you can determine whether a trust is right for your specific situation. Let's start with the basics. A revocable living trust is a legal document you create during your lifetime that holds title to your assets. You name yourself as the initial trustee, meaning you maintain complete control over everything in the trust. You can modify it, add or remove assets, change beneficiaries, or dissolve it entirely at any time during your lifetime. That's what revocable means. You also designate a successor trustee, typically your spouse or an adult child, who takes over managing the trust if you become incapacitated or when you die. The trust document spells out exactly who gets what, when they get it, and under what conditions. Now here's the number one reason people create trusts: avoiding probate. Probate is the court-supervised process of validating your will and distributing your estate after death. And probate in America is notoriously slow and expensive. Nationally, probate takes an average of 16 months to complete. 16 months where your family may not have full access to your assets. The cost ranges from 3 to 8% of your total estate value. For a $500,000 estate, that means $15,000 to $35,000 in combined court filing fees, attorney fees, executor compensation, and appraisal costs. For a $1 million estate, costs can exceed $50,000. But here's the critical nuance that most trust salespeople won't tell you. Probate costs vary dramatically by state. California has some of the highest probate costs in the country, with statutory attorney fees that can exceed $23,000 on a $1 million estate. That's a fee set by state law, not negotiable. Florida charges reasonable and customary fees that typically run 2 to 4%. Meanwhile, states like Texas and Wisconsin have relatively streamlined probate processes with simplified procedures for most estates. And many states have small estate exemptions that allow estates under a certain threshold, typically $50,000 to $100,000, to skip formal probate entirely. Before you spend thousands on a trust, you absolutely must research your specific state's probate costs and procedures. Assets held in a properly funded revocable trust bypass probate entirely. When you die, your successor trustee distributes trust assets directly to your beneficiaries according to the trust terms. No court involvement, no public filings, no attorney fees, no 16-month wait. This is a genuine and significant advantage. The second major advantage is incapacity planning, and I actually think this benefit is underappreciated. If you become mentally incapacitated due to dementia, Alzheimer's, stroke, or injury, your successor trustee can immediately step in and manage trust assets without any court involvement. Without a trust, your family would need to petition the court for a conservatorship. A conservatorship proceeding typically costs $5,000 to $10,000, takes several months, and requires ongoing court reporting and accounting. It's invasive, expensive, and stressful during an already difficult time. A trust handles the transition seamlessly and privately. Third, trusts provide complete privacy. Here's something most people don't realize. When you die with a will, that will becomes a public record. Anyone can go to the courthouse and look up exactly what you owned and who inherited it. Journalists, nosy neighbors, potential scammers targeting your heirs, anyone. A trust remains completely private. The terms, the assets, the beneficiaries, none of it ever becomes public. For people with significant wealth or complicated family situations, this privacy matters enormously. Fourth, if you own real estate in multiple states, a trust is almost essential. Without one, your family faces separate probate proceedings in each state where you own property. This is called ancillary probate, and it means hiring attorneys in multiple states, filing separate court petitions, and paying separate filing fees in every jurisdiction. If you own a retirement home in Florida and a cabin in Montana while living in California, that's 3 separate probate proceedings. A single revocable trust consolidates all of that into one seamless process. Now let's talk honestly about the significant downsides, because there are real ones. Cost is the obvious barrier. An attorney-prepared revocable living trust typically runs $1,500 to $4,000 for a straightforward estate, and $5,000 to $10,000 or more for complex situations involving blended families, business interests, or special needs planning. Online services like LegalZoom or Trust and Will cost $100 to $600, but they lack personalized legal advice and can create problems if your situation isn't perfectly standard. The biggest hidden downside is the ongoing maintenance burden. Creating the trust document is literally only half the battle. You must then fund the trust by retitling every single asset in the trust's name. Real estate requires new deeds filed with your county recorder's office. Bank accounts need paperwork submitted to each institution. Investment accounts require transfer forms. Every titled asset must be changed. And here's the critical part. Any asset you forget to retitle or any new asset you acquire later without putting it in the trust still goes through probate. An unfunded or partially funded trust is essentially worthless for probate avoidance. Estate planning attorneys recommend reviewing your trust and confirming funding every 3 to 5 years. That's ongoing effort most people underestimate. One especially important note on funding. Never transfer ownership of retirement accounts like IRAs or 401k plans directly into your trust. Doing so triggers an immediate full withdrawal for tax purposes, creating a massive and completely unnecessary tax bill. Instead, keep retirement accounts in your individual name and list the trust or individual beneficiaries on the beneficiary designation form. This allows retirement accounts to pass outside probate through the beneficiary designation while avoiding any tax consequences. Now let me bust some critical misconceptions. Myth number 1, revocable trusts save you money on taxes. This is flat out wrong, because you retain complete control over a revocable trust during your lifetime. The IRS treats all trust income as your personal income. You file taxes under your own Social Security number exactly as before. The trust assets remain part of your taxable estate for federal estate tax purposes. A revocable trust provides absolutely zero tax benefits. Zero. If someone tells you otherwise, they are either misinformed or trying to sell you something. Myth number 2, revocable trusts protect your assets from creditors. Also completely wrong. Because you control the trust, creditors can reach trust assets just as easily as if you held them in your own name. Lawsuits, judgments, and debt collectors have the same access to revocable trust assets as personal assets. Myth number 3, a revocable trust will protect your assets from Medicaid spend down. Wrong again. Medicaid treats revocable trust assets as countable resources for eligibility purposes because you maintain control. You cannot shelter assets from nursing home spend down requirements with a revocable trust. Only an irrevocable trust, which removes assets from your control entirely, can potentially provide Medicaid protection, and those must be established well in advance, typically 5 years before needing benefits. Now the question everyone asks, can I just use beneficiary designations instead of a trust? Transfer on death designations, payable on death designations, and beneficiary designations on retirement accounts all bypass probate automatically without a trust. For many people with simple estates, these designations combined with a basic will accomplish 80 to 90% of what a trust does at a fraction of the cost. However, beneficiary designations have important limitations you need to understand. They don't cover real estate in most states. They provide zero incapacity planning. They can create major problems in blended families because designations legally override what your will says. If your ex-spouse is still listed as the beneficiary on your life insurance policy or retirement account, they get the money regardless of what your current will states. This happens more often than you'd think. And if one of your beneficiaries dies before you and you haven't updated the designation, the asset may go to their estate or revert to probate. So let me give you a clear decision framework. You likely need a revocable trust. If any of these apply to you, you own property in multiple states, you have a blended family with children from different marriages, you have a dependent with special needs who requires ongoing management, you want incapacity protection without court involvement. You value keeping your financial details private after death, or your estate is large enough that probate costs in your state would exceed the trust setup cost. You can likely skip a trust and use a simple will plus beneficiary designations if your estate is straightforward with no complicated family dynamics, most of your assets already have beneficiary designations, you own property in only one state, your state has simplified and inexpensive probate procedures, and you're comfortable with the probate timeline. One final critical point, even with a trust, you still absolutely need a will. Specifically, you need what's called a pour-over will, which catches any assets that weren't properly titled in the trust name and pours them into the trust at your death. It's also the only legal document that can name guardians for minor children or dependents. A trust without a pour-over will is incomplete estate planning. My bottom line recommendation, start by researching probate costs in your specific state. Calculate whether the trust setup cost is justified by the potential probate savings. For estates over $500,000 in high probate cost states like California, New York, or Florida, a trust almost always pays for itself many times over. For smaller estates in states with streamlined probate, a goodwill with proper beneficiary designations is probably all you need. And whichever path you choose, review your estate plan every 3 to 5 years and whenever major life changes occur. If you found this strategy spotlight helpful, subscribe for more retirement planning education. And if you want help determining whether a trust makes sense for your specific situation, check the link in the description for a free consultation. Class dismissed.
Hey, before you go, if you're serious about your retirement, we'd love to help. Scan the QR code on screen right now or visit the link in the description to book a completely free strategy session with a qualified professional. It only takes a couple minutes to fill out, and there's absolutely no obligation. Take the first step today. We'll see you in the next one.